So thank you so much for being here, and I hope you've attended the sessions and you've liked the sessions. In one of the early sessions, which I was there, and one of the hosts made a statement when he saw that there were less people in the room. He says, "ये अपना सत्संग नहीं चल रहा है, जहाँ पे हमको भीड़ इकट्ठी करनी होती है. This is a very specific knowledge-based session, and I think anyone who's hungry for knowledge will definitely make sure he or she is present physically and mentally, both." So, ladies and gentlemen, without much ado, I'm very happy to welcome all of you in this session. The host for our session is going to be Ms. Gopi Trivedi. She's a senior partner with YJ Trivedi and Company, a leading IP firm in India. She would be hosting the session, and Gopi would be taking you through multiple choices, and we have a very esteemed panel with us. So Gopi, over to you. I think, please take us all through this lovely session.
Thank you. Hello. Good afternoon. Thank you, Umesh, for the introduction and giving us a get set go. So with me, I have a very esteemed panelist, Mr. Bhargav Hemmige, Ms. Lakshika Joshi, and Mr. Niraj Jain. So 4 of us will take you through these nitty-gritties of legal and IPR, and why are we talking about it? Why software industry should be concerned about it? In fact, as we know, every business has to be concerned about legal and IPR, but in specifics, the software and semiconductor industry, since it's doing wonderfully well, has to be more careful at the right timings. And that's what my panelists will throw light. They're going to share their case studies, some use cases, some reports, some statistics, and we'll understand. Of course, it's a brief period of time we are going to share our insights, but yet, see, since you're all from this software industry and you know the numeric importance as the industry as a whole, the number of job creation, the GDP contribution by this industry, so on and so forth. The industry itself create a lot of intellectual property, and those intellectual properties are being benefited in all other allied industries. So it's a very, very beautiful interconnection or intertwining of various intellectual properties. I think this hall itself is full of several IT-based products which might have intellectual property rights, and of course have gone through various legal compliances in their lifespan. And that's how beautifully we are using, no matter whether the mic which I'm using, or the cameras, the videography is being done, the mobiles, and so on and so forth. So not a single object is spared. So this beautiful industry is giving us a very efficient way of working in our daily lives. The problem-solving approach of this industry is helping us to, scale up several avenues. And from Industry 4.0, it is about to switch or already smoothly switching to Industry 5.0. And everything is possible only and only through the software industry. So we, as being lawyers on this side mostly, are kind of very amazed to work with the software industry. Somewhere we have those elements, but yes, the entire software industry, I think, has been doing really amazing. The datas and everything, they all will share. But just one thing I would like to share from my end is the World Intellectual Property Office, that's WIPO, has recently announced the Global Innovation Index. And I'm very proud as an Indian to share with all of you, and I'm sure you equally will be proud of that. We have this year ranked 39 from 81, which is like just in 10 years of span, we have scaled up to 39, and that's really a matter of pride. And again, all industry, including software industry, has contributed significantly well, right? And one myth has already been there for quite long time from the patents side, the Indian patent side, that there's one specific section which inhibits the patent grant of software industry, which has been smoothened, which has been clarified, by the patent office itself, and eventually from 2016-17 onwards, the patent filing in India has increased by leaps and bounds, and I would be very, very happy to share with you the statistics. If I, come to the right numbers, there are some in last report of Indian Patent Office, that is IPO, 2022-2023, which says some 20,000 plus patent applications were filed by the software industry. And out of them, or prior filed, some 3,700 plus patent applications have been positively granted. So I'm very glad, very happy that this myth has been, busted out. The stakeholders are really contributing well. And at the same time, various legal compliances are also being taken care, so risk is minimized. And now I would request all my panelists to kind of share their more light on this. But before that, let me have the formal introduction of each one of them. So I have with me a very young lawyer with me, Mr. Bhargav Hemmige. So I would be very happy to start with Mr. Bhargav. So Bhargav is a founding partner of a law firm named Trine Partners. And he majorly practices in corporate law, employment law, IPR, and disputes. They assist several entities, more particularly in the IT segment, with their commercial contracts and employment law matters, as well as their commercial litigations. So welcome, Mr. Bhargav. So we have with us Mr. Niraj Jain. He holds a master's degree of law and currently leading the Legal and Compliance division of QX Global Group. He oversees and delivers comprehensive legal and compliance services across various business verticals. He has more than 15 years of experience in industries encompassing from e-commerce to KPO. His special interest in intellectual property, that is IPR, enables him to manage issues with legal and commercial aspects of the transactions. Welcome, Mr. Niraj. We have with us, so while we have these two speakers from Ahmedabad, we have one speaker from Delhi. So may I welcome Ms. Lakshika Joshi from Delhi, who is a senior director, legal at Capgemini Group, and she's responsible for strategic commercial contracts, negotiation, compliance, and risk management. In addition to her corporate legal responsibilities, she leads Capgemini's intellectual property right practice across the globe, ranging across 50 countries. And Lakshika started her legal journey as a litigator at Delhi High Court, and then she hasn't ever stopped then after. And beautifully, she describes herself student forever. So welcome, Lakshika, and welcome all of you. So we'll start with Mr. Niraj for his deliberation. So over to you, Niraj.
Good afternoon, everyone. So I'll give you a little brief more why legal and IPR is more important, as we are into a digital world today, and the era of digital is quite a fast moving space. Everything that we do, we give our consent on mobile, we give our consent on emails, right? This is an era of digital where you don't need physically present on every aspects of life. Prior to that, we were digitally not there, so we had to go physically everywhere, sign up, agree upon, and deliver it. In most of the cases, we talk everything digital, right? So if you have to go to a bank, no, we don't go to bank most of the time. We go to a mobile app. You deal it and deliver it. So everything that we see is somewhere IP is associated with your legal consent and compliance. Without that, no transaction happens. We talk about various layers of two-factor authentication as coming. That is also an enabling of IP encryption process, which enables us to move to the next level. And once you give an OTP or the factor authentication, you've given your consent in principle. Now you go to any forum and say that, oh, I've been duped or I've been cheated. There is no point because you already agreed upon and given your rights on that. So it is better to read what you agree upon, what you sign upon, what you enforce upon, because it's your consent giving act which we are doing it. And looking to the fast moving pace, we are moving with the pace, and by accepting all this, we agree to everything. So that's where IP built by companies, utilized by customers, and the customers been implementing and using it. So we should be giving a consent-based journey and utilizing learning-based journey here. So I would call IP and legal goes in hand, and customers should benefit out of it, but by making sure that they do not get deprived of it by not reading it or not understanding it. So please read it, understand, and then deliver what is your outcome. At the end, it is a consumer-based industry. Most of the people have come in. So that's all I wanted to give on IP and legal.
So Lakshika, can you share some, kind of your case uses, some best example which you faced while dealing with cross-border IP transactions and, things alike?
Thanks, Gopi. Thank you, audience, for bearing with us post-lunch. We hope to keep you awake. Just an effort towards that. I'm not going to consult any notes or any pre-discussions we've had on this topic. Let me just go basis the pulse of this sort of forum and this room here. And I can see right in front of me the topic again, so I dare not digress from it. It says leveraging business with the power of IP and legal. And I'm going to just keep it very simple. After all, it's all focused at business. I am an IP lawyer by profession. I head IP for a large conglomerate and multinational company, but ultimately, it all boils down to धंधा किधर है, पैसा किधर से आना है, ठीक है? We are all in it to make money. And essentially so because we are in business. अगर अपने शौक के लिए दो कविता लिखनी है, कहानी लिखनी है, वो IP अलग है, ठीक है? You have copyrights in it, that is IP, but maybe you don't want to monetize it, you don't want to commercialize it, आप उसकी बुक छपवा के अपने घर में अपने पास रखिए. But again, अगर आप commercialize करने के लिए कर रहे हैं, you want to sell, then we are talking business. And the minute we talk business, I think the way we want to look at IP and legal and how they can be leveraged to support your business is what we should be talking about and what I should be able to sort of share some points on. So I'll tell you what all of us are doing, whether it's a small company, a startup, or a large conglomerate. We are all making some products or services or solutions or something else, right? Now, when we do that, what is it that we are actually doing? We are all creating intellectual property. It could be a brand. Somebody may think that only patents is IP. Of course not. Even if I'm not in business, there is still IP around me. There's IP that I breathe, I live, I touch, I feel all the time. I use this mobile phone. It's got like 1,000 patents here, which are getting licensed to be able to create this mobile phone. There's a certain brand it uses, that is trademarks that using. I'm wearing a particular sari from a particular state in the country, which is a geographical indication, which is an IP. So everything that I do from the morning when I wake up to when I go to sleep at night, there are various things that I'm working with or dealing with or touching, and there is IP involved. And this is IP from high-tech patentable IP to, trademarks, copyrights, and so on. Now, when we talk of IP, it comes with a certain kind of so there are two types of intellectual property, and we need to be aware of that. One is personal and one is industrial. Personal is the one that I just gave you an example of, like, let's say, copyrights, which is personal to you. Industrial is like your patents, your trade secrets, which you can utilize to do commerce. And therefore, they need to have a connect with industry. And that is the kind of IP that will give you revenue if you're in business. That is the kind of IP that you need to protect essentially to be able to do business. We know many companies, and I can cite a lot of examples. At one point, Kodak, which used to make cameras, was a very successful company. Eastman was one of the pioneers of that technology, the whole camera thing, the camera business. But do you hear that name any longer? If you, do you even go to purchase cameras any longer? No, because cameras are all the time with us, we don't need that, right? But at that time, Kodak had a lot of patents. They sort of totally missed the bus because they did not focus on the right places where they could have focused on IP to boost their business rather than just keeping it locked up somewhere in their sort of corporate offices. Similarly, Xerox. Photocopying, we almost call it synonymous with Xerox. I want to get this paper Xeroxed. Xerox is actually a brand name. It's the name of a company. It's an IP. It's a trademark. It's not actually photocopying. Photocopying is the verb, and Xerox was a noun, which is the name of the company. But they did not protect their IP. It just was being used as a verb. So that's how, what I'm trying to say is some very big, large conglomerates over the years we've seen have not been able to protect what was dear in terms of intellectual property, and they lost the bus there. Just to give you an example, Amazon started as a bookseller. It was an online bookseller. And now what does Amazon do? They leverage that brand. It was just an online marketplace for competing with the likes of Barnes and Nobles. But now, who is Amazon competing with? The Microsofts, the Googles of the world. It's a tech company. From being a bookseller, they evolved and leveraged and protected their IP at all steps, whether it was in their algorithms, whether it was in creating an aggregated marketplace for people to come and sell products. They've leveraged that into their business. But when we say IP doesn't just stop at patent, trademarks, trade secret. At least as a practitioner within a company, I've realized what also happens is sometimes we are creating a lot of very good engineering products or solutions. And these are patented. And now I know that there is a global market for it. I have created this product, let's say, in the US office or in India, and now I want to sell it to a very large customer in the defense sector in, let's say, Europe. I have a great deal of several $1 million, and I'm very excited, and my sales team is very excited, and they just go and sign the papers. And that's when we come in. I mean, of course, the bad cops in the company, the lawyers. Ideally, they would say, well, what's your problem now? You're an IP lawyer. We've checked all the boxes. It's patent registered. We've done the branding for this product. So trademark is done. All boxes are checked. And that's when I ask them some other questions. In my capacity as beyond IP, but as a lawyer for the company, I ask them, all right, so how did you build this product? And they'll describe all of that to me in fancy technical terms. And that's when I realized that, oh, so it's a software product. So are you using any encryptions in it? And everyone, because Niraj just gave you examples of why certain things need to be protected due to cybersecurity threats, due to data breach threats. So everything that you're consuming in digital needs encryptions. Everything comes to you encrypted. Your WhatsApp is encrypted. Your messages are encrypted. So these packets go from your phone to another phone. In between, no one else can read that message. That is what encryption is. Even the simplistic things that are moving on websites or your phones are encrypted. All websites that start with HTTP means they are secured, they're encrypted, right? Now, I ask my engineers, okay, so are you using encryptions? And they'll very proudly flaunt off, yes, we are using encryptions. So we are cyber protected, we are data protected, we are using encryptions. And that's when I tell them, oh, did you do an export control check? They said, what is that? You never told us. That is not IP. That is not legal. We are good on cybersecurity. We are good on data protection. We are good on intellectual property. You just don't want me to do business. That's what they'll tell me often. And then I tell them, no, my dear. Also understand that with legal also comes a very strong part, which is regulatory. Now, what is regulatory? Regulations are what authorities are telling us to do. So every country like India, we have the DGFT, which is the Director General of Foreign Trade, will have these offices. In the US, you have BIS. You have these offices, and there is something called export control. There's something called a Wassenaar Treaty, where countries have come together and signed this agreement that any dangerous substances, nuclear substances, radioactive substances, and so on, cannot get proliferated to bad actors in the globe. So it could not go to countries which can use it to cause damage to humanity. Similarly, some technologies have been qualified and they are export controlled. Means if there's a technology which can be dual used, So encryption technology sounds very good when we're talking of data protection and cybersecurity. But imagine if the same technology falls in the hands of terrorists. They could very well also conduct their businesses without anyone being able to intercept their activities. And that's why countries come together to control these things, which means then there are controls. So every time you build technology or solution or a product or an asset which uses anything with encryptions, you need to apply for a license to be able to export it from that country or to import a similar technology into your country. Most of the countries have that. So suddenly you realize that a great solution, you've signed a deal for millions of dollars because you're licensing it to a large company in Europe. You cannot send the technology outside the country just because you don't have an export license. That's the job of legal. IP, yes, good, but IP also comes with some regulations. Legal comes with some regulations which are beyond what is written in the books, the textbooks of law. And that's also what we as lawyers need to understand and guide businesses on. And therefore, if we understand how business functions, while they're building what they're building, those products, assets, and solutions, we'll be able to tell them in time, hey, you're building this will need some encryptions. Why don't we approach the authorities for a license? Because doing it post facto means delaying the project for several years. But again, I'll not take too much time. That was just to give a segue and an example of how legal and IPR comes into play to facilitate business at a global level.
So thank you, Lakshika. It was quite a great, drive through this entire journey. But we can very well relate. I'm sure the audience will relate that all these checks should be done periodically. Of course, depends on what project is being floated right now. So that the last minute bad cop, the lawyers would have a kind of a tick marks of them also, and the business can leverage, flourish in the software side too. So that was a great insight. So now, Bhargav, so we would like to hear from you, your insights about the legal compliances, especially in the software industry.
Hello. Hi, everyone. Thank you, Gopi Ben, for a very kind introduction. As Lakshika ji mentioned at the very beginning, that she wanted to first touch base upon the topic that is very well pinned over there. So the topic that we have for today is leveraging business growth with legal and IPR. There are a couple of keywords in the said topic. The first keyword is business growth. The second is legal, and the third is IPR. IPR is something which has been very categorically and vividly dealt with my fellow panelists here. So if we look at the first keyword, which is business growth, there are two definitions in my unsolicited opinion insofar as business growth is concerned. The first definition of business growth is something which is tangible, something which is visible. Right? If a particular business is growing by virtue of a tech professional or by virtue of any business professional, by infusing his or her time, money, energy, resources, and everything, sweat and blood, into that particular business, and by virtue of him or her having infused all of those resources, if a client has been converted, you build that particular client, you receive a certain amount of money. That is one tangible, visible definition of business growth. The second intangible definition of business growth is mitigation of risks, is limiting the amount of exposure of liability over you. And the most important, the latter one, which is an intangible or a non-visible mode of business growth, helps you sleep peacefully at night. आपको चैन से रात में सोने देते हैं. Right? So therefore, if you are earning, say, 1,000 rupees from an ex-client, with a premonition in your brain that you might have to pay 1,500 rupees tomorrow from the money that you have earned, you have actually attained no growth. It is rather a loss that you have done. So therefore, it is equally imperative and incumbent in today's time and age, considering Kali Yuga has come. So therefore, the amount of trust that people have over one another is really reduced to a drastical extent. So therefore, it makes all the more sense for us to be devoting some mental space and capacity towards those intangible business growth propellers. And one of the methods of achieving that growth, one of the methods, is through having a very robust internal mechanism in terms of legal documentation. Right? Whether that be with your employees, whether that be with your clients, whether that be with any other person, have a very robust, clear, disambiguated, certain level of agreements. Right? It should convey the purpose that you're wanting to provide for in a very crisp manner, in a very clear manner, unambiguous manner. right? That is one. Rather than delving into something which may be very complex, right? So there's an analogy that I had read somewhere. This is definitely not mine. This is borrowed, pure plagiarism. Please bear with me, right? So one analogy that I had come across is that I'm wanting to lean towards understanding what a non-disclosure agreement is, because that is the most basic form of an agreement. Everybody here might have come across that particular agreement in some point in their lives, right? So a non-disclosure agreement is basically, as per public perception, right, will be an agreement that regulates the amount of information that is required to be shared from X person to Y person, and what do you classify as confidential information, and how do you protect the dissemination of it. Right, that is the main purpose of it. As opposed to all of those Gita-like documents, which are like the master service agreements, or reseller agreements, consultancy agreements, end-user license agreement, distributor agreements. All of those agreements are very junky novels written by very reputed authors. But a non-disclosure agreement is a short summary or a very simple short story written by the same authors. Right. So though there is always a perception that is there in the minds of the people that a non-disclosure agreement may not be looked at. Right. कि इसको क्यों देखने की ज़रूरत है? Right. If you are, I understand that there is some amount of urgency and there is some amount of excitement that is there within every business owner or business professional's mind that I want to be incepting relations with this particular person. He has sent in NDA, I'll just sign across and give it back. Right, that is always there. I understand that. But then at the same point in time, if you do not do your due diligence at the stage of an NDA itself, it sets the tonality of the discussion further. Right. If you are not doing your due diligence at the stage of an NDA, what essentially it is giving a perception to the other person that you're entering into a business relationship with or proposing to enter into a business relationship with is that ye bande ko hum log daba sakte hain. Right, he has not done his due diligence. He's not concerned about the interest that he has. He's not concerned about what is right, what is wrong. He has merely signed on whatever document we have given him. Right. Nowadays, since I had mentioned about Kali Yuga and coming back there again, right, in today's time and age and of late, I have seen in my recent work that NDAs have clauses such as a non-solicitation clause, a non-compete clause, a liability waiver clause. These clauses have no space in an NDA, to be very honest. Why are they seeking refuge in this house is something which is absolutely ununderstandable. But nonetheless, they are. Right? The reason that they are here today is because of the public perception that I mentioned about. That people are not doing their due diligence. Question the other party, why is this clause here? And obviously, if there is a clause that is supposedly an NDA has been entered into between X and Y, it may not always be so that you would end up doing business with the Y person. Right? You might be only exploring certain business prospects with the Y person, and in the course of you exploring certain business prospects with the Y person, you are entered into an NDA, wherein certain information is being transmitted from the Y person to X person. We use that information, and subject to everything going well and everything being smooth, we convert that prospect into a confirmed relationship by way of a definitive document. But if you have agreed upon a non-solicitation clause, agreed upon a non-liability waiver clause, agreed upon a non-compete clause at the very beginning, if that is not subsumed in the further definitive documentation, agar wo wahan pe capture nahi hua hai, this first document will always have an overarching effect over all the future documents that enter into. Right? So therefore, it becomes all the more imperative for us at today's time and age to ensure that your due diligence is straightforward and good. You should have a very robust system. Right? Now coming to those junky novels that I'm talking about, I'll give a very brief outlook. The most important part that is required to be looked at when we negotiate any MSA, SLA, all of these documents, these chunky documents that we're talking about, is how much is the liability that is going to be foisted on your heads? What is the quantum of the liability and what is the nature of the liability? What is the maximum amount of liability can I be subjected to? And what sort of liabilities can I be subjected to? Am I liable to direct damages only? Am I also liable to indirect, consequential, and incidental damages also? That is one thing that you will have to capture in the agreement very categorically, very certainly, without any ambiguity. Right. Second is an indemnity clause. Right. Because an indemnity clause will also have to be read with the limitation of liability clause that I mentioned right now. Right. And if there are any exceptions to the indemnity also. Generally, if a tech company is in the business of developing a particular product or a solution for somebody, then there is generally a clause in the agreement which says that if I am the tech developer and I'm developing an e-commerce platform for, say, Gopi Ben, then Gopi Ben would definitely want there to be a clause in the agreement which states that Bhargav's service or Bhargav's product should not be infringing any third party's intellectual property. Right? That acts as an exception to the limitation of liability. right? So supposedly, if for any other losses that might be ensued, there might be a maximum liability cap of say 50,000 rupees. But if there is any liability that arises by virtue of me committing any infringement of an IP of a third party, then there is no liability cap. Those exceptions will have to be captured in the agreement. Right? If I'm a service provider, if I'm a product developer, I should have certain acceptance criteria in the agreement. If I'm providing a service, what is my acceptance criteria? If there are multiple sprints or milestones that I'm running through, what are those sprints? What is it that I have to fulfill as per the criteria to be, ticking that particular box that yes, milestone 1 has been completed and will not be revisiting to milestone 1 again? What is it that I do? As a service provider, I should be concerned about what happens if I'm not paid. Do I have the right to be retaining the work that I've already been given to, that already has given to the other person? Do I have the right to ask for the money back? Do I have the right to keep the entire work with me? What do I have? What rights do I have as per the agreement? Those rights will have to be captured in the agreement. That is second. And insofar as your dispute resolution mechanism is concerned, do you have an arbitration clause in an agreement or not? That is something which might work. If a party is based out of Ahmedabad and the other party is based out of Delhi, can we agree upon a mutually selected arbitration location, say Mumbai? Right? Do we have an institutional arbitration or an ad hoc arbitration? That is something that we might have to discuss upon. Right? All of those things. So by the end of it, I would merely want to say that please keep all of your agreements very crisp. That's a myth that I want to be debunking here right now. That do not vouch for your agreements being very concise. You're not achieving anything doing that, right? Even if you're spending an additional amount of time, money, energy, effort in getting your agreements in place, it's for the betterment of both the parties itself, right? Because that agreement that you have signed today is going to be remaining in your system for the next 3 years until a problem occurs. That one document that was signed 3 years ago is going to be plugged out from the garden of agreements from your system after 3 years, where neither you remember nor the other party remembers what was signed by us prior to 3 years from today. Right? So therefore, if you're signing the agreement today, if an additional amount of time is invested, additional amount of resources are invested, so be it. Let it go. Right? So that's what I want to leave this thought to you guys to be deciding as to what is important and how do we take this forward.
So if we continue with the Hemmig's words and kind of the advice that the time invested for vetting the documents would be time invested for the business growth. So I think henceforth we all will take sufficient time and sufficient legal advice and help for vetting such a piece of document, and also will not consider it as either concise or verbose, will rather consider it as a complete one. So with that, I'll have the next question to Mr. Niraj. So Niraj, can you share the key legal practices QS Global Group has implemented to effectively manage the international business risk and make strategic legal decisions? Any such particular tip?
Yeah. So my colleagues have covered a lot of insight about legal, IPR, compliance. Now we will talk straight away what practices normally we follow at international business arrangement. So there would be required of a framework, compliance framework, which we need to have comprehensive compliance framework, which requires anti-bribery, anti-corruption practices, Foreign Corruption Practice Act, various compliance which we take care. Thereafter, there is a cross-border contract management, which Bhargav has quite touched upon the contract, what it looks like. So there are a cross-border contract management where we need to make sure that the arbitration governing laws or any other aspects which are very precisely written with the forum that they are in. And then we move on the IP structure, because when we sell a software services or sell a product and their enforcement of the IP as well, what happens to your IP breach tomorrow? How are we protecting our IP? What are the liabilities associated to the IP breach, right? So that all takes care as an IP structure and the enforcement process. You know, this is a digital world where we digitally give every aspect of the information through a digital mode. Sometimes the source codes are copied upon, your systems are replicated or duplicated by your clients. So this IP structure and IP clause are designed in such a fashion that it recovers your interest rights and captured it for the future purpose. Then further, it looks like a text structure and enforcement. So there is also a structure compliance which also comes in, the transfer pricing amount or cross-border treaties which she talked about on the various aspects. So these are all that captures at the time of drafting these contracts and negotiating and discussing. Further, there we go on the data privacy and cyber squatting. Now, data privacy is concerned with GDPR compliance or California Consumer Protection Act or various other protections of global compliance standard which are incorporated gradually, making sure that we are compliant with all data privacy and compliance. Then further, it comes within employment and the labor compliance law when we draft a contract. Because the client on the other side is also concerned. There are local laws which enforce that the employees are made redundant, made to be hired by the companies which is making the redundance of the transferring the business. So the companies in UK, US are concerned about all this compliance of local labor laws. So under that, we also make sure that the labor laws liability does not pass it on the clients. We have to ensure governance should be provided to them, saying that how are we rerouting this business. So there is also a local laws of the compliance which we would have to deal with, and making sure that our employees are also safe with the local laws of compliance with the policy and the process and the system. And then we comes with an ethics codes and the governance. So we would also have to be compliant with various ethical codes and governance process for all those systems that we have placed in contract, and making sure what we delivered as a services. So these are all various factors which are concerned and kept under. And finally, the most important and the critical aspect of the contract would be dealing with dispute resolution, arbitration, what Hemang also emphasized on, basic forum where we are. When we are in India, can we keep a neutral jurisdiction? But when we go to the international, we have a various forum to be considered upon, depending on the consideration that the client can afford and go on. And it's also depend on the value and the volume of the contract that we are in. It's not always that we would always go with an arbitration. So there is no thumb rule that what we agree upon the governing law or the arbitration would always be same. Further, there are various aspects that we also make sure that non-solicitation would be more important when you are a service product. When you are a product-based, you would make sure that unless you don't make sure they will end up a contract with exclusivity or something. And there is a most important is an exit mechanism. See, when you know how to enter the business, you also need to make sure that your contracts are well written for an exit mechanism route. When you don't know how your exit mechanism look like, because you would have to question when we say we are a bad cop. Yes, we act as a bad cop in our organization because we are the last person to stop the business to go faster at their pace that they want to. Because all the business owners wants to have their contract closure at as of yesterday, and not even today they wanted to wait for it, because I will raise an invoice, I get my money. Even they don't want to consider the payment timelines or the process or any system. We got all approvals, yes, this is there. We would have to ask them, what is exit mechanism? What will happen if it doesn't pay? What will happen if this doesn't work out? How are you going to deliver? What if we don't deliver it as a service? What is the guarantee that our scope that we are committed or over-committed or has been foolproof read by us as a system or a process? Yes, everything is done, everything is. Then the question arises, are we confirmed that what we're doing it as in process to exit is correct? See, these are all steps that make sure that open the eyes of the business owners at times. Oh, are we committing this as well? Are we doing this as well? That time the systems understand, no, we are over-committing, but we are aware now this is a risk. And that's the exceptional approval goes it and then enables them to sign the contract. So contract within IP goes all hand in hand, because every skill that human gives it here is also their intellectual skills that they come with individually. And that skills make sure that evolves as a product or a services tomorrow for each of us or at the end client end. Because we provide a skill set of our developer will become and work for hire for the client, making sure that he doesn't steal the IP. So we need to make sure that the contracts with the employees are also watertight. So thinking from the various angles, the legal framework of the international business requires a lot of insight about it. Covering in 5 minutes or 7 minutes, still a Herculean task for me to give you more insight. But I will leave it up to my other panelists to take it more insight from here. Thank you, Gopi.
Hello. Now, very rightly pointed out, Niraj, that the businesses when transacted across the borders, not only the local or national laws, the other countries' laws also come in play, and you indirectly or directly become compliant to it. So you can't ignore it. So better you kind of deal with it at first hand. So true. So now we want to hear from Lakshika that the entire world, including IPR attorney like me, we are all talking about IPR, and it's a game changer. The economy indeed revolves around it, and the audience also knows very well. But have you come across any such experiences that you kindly had to drop IPR, or kindly you have to you have to lift a very small IPR which could become a game changer? It's just otherwise.
Multiple, is that good now? Yeah, I think it's working. Multiple such instances where we had to drop, and also a small IP brought big gains. But even before that, there was a theme I heard between Gopi, you and Niraj, where you were talking about multi-jurisdictions. A very interesting thing that I want to point out to the audience is, understand that intellectual property rights are territorial in nature. Every country has different intellectual property laws, and business is done globally, which means that's why you need IP lawyers, because you cannot handle IP businesses unless you are conversant with how those nuanced changes are across the globe. Now, this can cause some complications. Some very simple things like when we do, and you were talking, Bhargav, about employment contracts. So usually in India, we would have a clause which says that when I sign up for a company, it says that any work that you do within your employment with the company belongs to the company, blah, 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 blah. But there are countries which do not allow for this. You cannot have the employment contract say that any and all work done by you within the term of your employment belongs to the company, because it is against the labor policies of those countries. So every time your employee or a person who works for you creates a patent or a copyright or a trademark or any piece of IP, you have to do separate assignment agreements with them on top of their employment agreements. Then there are also jurisdictional nuances, like we were doing a matter, and there, in that there was software code involved. So software code typically would be protected through copyrights, and we would register it with a copyright authority in the relevant country. US and India, pretty similar. Most of the common law countries are pretty similar in that sense in their protections. But an interesting situation came up in France, where even though the employee had assigned all copyrights in the software code to the company, we realized that the software code also came with GUI, which is graphic user interface. In France, for any graphics, you have to have a separate agreement for assignment. Because even though the employee assigned all rights whatsoever, whether now or in future, to anything or related to the software is assigned now to the company, the graphics are still not included in it by definition, even though you say including but not limited to, because the law is such that it will keep graphics, pictures, photographs outside. So then we had to do a separate agreement on top of it. Now the same employee assigning just the graphics that they did for that software on top of that to the company. If we hadn't done that, we had lost out the entire IP, because the meat of that solution was in the graphic user interface. Even if I had the copyrights to the code as a company, I would have done nothing if the GUI had gone away. So that's one example. But there are also exercises that we do where we realize we do something called an IP audit very periodically, because we realize that there are certain patents we hold, and the technologies have moved, at a pace that those technologies on which we had those patents they don't even make sense now. these are codec or some other kinds of technologies which actually are not pertinent, because now we are dealing with things which will have redundancies if we were to use those technologies. So there's no point maintaining that patent. For patent the life is 20 years, but just for your, as a refresher, you need to keep maintaining your patents by paying patent fees at every 3.5 years, 5.5 and 7.5 years throughout the life of the patent. So life of patent is 20 years. Technology these days changes every 6 months. I mean, you must have an IP audit process in your company, because you'll realize that why are you paying money to renew and maintain those patents when that technology has moved leaps and bounds? You don't even need that. So you just give away all of that kind of intellectual property. But I mean, there are hundreds of such instances, but I'll limit myself to this right now.
It's such a interesting case study. If not, but that's if not from anywhere, but that's from France. That the GUI has to be kind of taken care separately, right? So just to extend what Lakshika has just said. She's absolutely right that has to be renewed. So in US, it has to be renewed from 3.5 to 11.5 and so on. But in India, it has to be renewed every year. So that IP audit, the period of that IP audit even had to be made smaller, or accordingly, right? You may make decision for coming 2-3 years. So that's another exercise again. So Bhargav, if we hear from you that what the importance of documents and the nuances you mentioned just now, so what difference do you see if there is in front of you, there is a startup, and if there is an MSME in front of you? So how differently, or how with soft nuances, how do you find the changes in these two different activities or two different business setups?
So essentially, if I talk about a startup, one thing is a given, that there are limited amount of resources with a startup, right? So therefore, unlike an MNC or unlike a company which has been operating in the said field for a very long duration, which need not worry about finances or monetary aspects or certain other operational aspects, a startup has certain limitations, right? But nonetheless, there has to be certain amount of mental capacity, certain amount of mental space, certain amount of resources that are required to be dedicated to ensure that you're not run over, right? And when I say you're not run over, it starts just as charity begins at home is a concept that everybody is aware about. So therefore, similarly in a startup, if you are a person starting an organization with more than one person, right? Supposedly we're starting an organization with 2 or 3 people, at the very least, you should have a founder's agreement in place, right? Because you're not the sole decision-making authority. There are 2 or 3 other people who are treating the same startup as their baby. That baby is equally important for all those 3 people also. So therefore, the founder's agreement should very vividly and categorically mention what are the roles and responsibilities of all the 3 persons in the startup, what is the decision-making authority, insofar as sales is concerned, insofar as delivery is concerned, insofar as client-facing is concerned, who has the authority to take a call. Right? That should be defined. And if at all there is any sourness that happens in the relationship of the 3 people who are the founders of the company, how do we deal with that sourness in a manner that protects the interests of the directors also, but at the same point in time also ensures that the company is not affected or the reputation of the company is not affected. It should not be so that if there are 3 people who are fighting amongst themselves about something, it should not come up in the market, or there should not be a perception that is created in the market that the company is down to the docks. Right? You should maintain that sort of sensibility while we are fighting also. Right? So therefore, that should be mentioned in the agreement so that it navigates the process of you resolving your disputes. That is one for a startup. And startup MSME, I'm using it synonymously. Right? So insofar as navigating further things are concerned, you should also have a very robust internal employment mechanism in place. Right? Have your HR policy manual handbooks all in place. Have your employment agreements in place. Have your consultancy agreements in place, because if you are a startup or an MSME, you are not somebody who already has 100 clients, right? You would want to get on board a sales personnel from some other company, offer him or her certain amount of equity in the company, and say, "Ki boss, please work in my company, and you help me generate leads. You connect me with certain persons from certain other regions, and then I will close all of those or try to convert those leads into final clientele." Right. So therefore, that sales personnel of the company today has access to anything and everything of your company. He has access to all the current sales lists. He has access to all the confidential information of the company. He has access to anything and everything. So tomorrow, if he resigns or terminates his association with the company in a manner which was not mutual, I do not want that particular person to go to a competitor or any other person and start maligning the image of the company. That is one. Disparaging the image of the directors. That is two. And thirdly, misutilize the information that he gained access to during his tenure with the company. Right, this is three. So therefore, employment systems have to be in place. And third, as I had previously also mentioned, that have your agreements also drafted in a lucid manner. It's a one-time thing. If you do not want to be engaging a lawyer on a permanent basis, so be it, not a problem. I understand that you have limited amount of resources, but at least shell some amount of money at the very first stage, right? And have all of those systems robusted, have all of those systems in place so that it does not pinch you later.
Yes, that sounds interesting and very, very relevant. Since you're starting something new, you have to be kind of extra conscious, and why not to, when you are in kind of kindergarten, start learning the nuances right from that day one, and it would give you the, brightest fruits. Okay, so now I think we are concluding the session. The takeaways are we will be extra cautious for all our legal compliances. We'll be kind of hiring the legal advice whenever required on beforehand, not in the time crisis. And in whichever scale of business we are, or whichever importance or urgency of that project completion or transaction we are. So this is a kind of a tip or a pledge we are taking. So thank you very much, panelists. Now I'm handing over to Mr. Umesh for taking it ahead.
I hope the session was good. I had to step out in between. I think we have time for about 2 questions. If there are any questions, please. Would you want a mic?
You're quite loud and clear.
Yeah, and we work very closely with legal community, right, hand in hand. So I come across a case in my career. Of course, I won't, dilute the company name and all of that. What happened? There was an associate and very structured organization, right? All formulates policies, practices, ISO standards, GDPR certified, all of that. Now, we have employment contract and that non-solicitations and non-compete were there. And yes, we also spoke to lawyers, legal consultants also. And we referred to all the acts, ID acts and standing orders. None the labor laws talked about solicitations or competition, right? And what we found out is in the court, and maybe Lakshika ji, you can talk about it. In the court, those non-solicitations, especially on the labor code, doesn't really stand out. So there is a gray area that has come out that even you sign up a non-compete and non-solicitation, in India, under the labor laws, that is really didn't define. So you can't penalize or put someone because the labor court or the judge can always challenge you why you did it. And that that can get into a wrong way of taking any penal actions. Now we then studied with a very large IT company. We found out some of the practices they did, and in Chennai High Court, the judge has even scolded the management. They penalized the company also. Very large IT company, very formulated. Again, I would not disclose their name. They had to bear about a CR, about a 1 crore value to resolve the dispute. Now, these are the challenges we face while we are on the other side of it, because we have a management to deal with, business, and we have a lawyers to deal with. Our management says, okay, lawyers are roadblockers, so do HR. Yeah, but is that, yeah. So my question.
Basically, HR raises it to management and management approaches legal, which is us. Say that we need to get something done. What can be done? So basically it becomes then from yours, it becomes our headache to figure out how do we deal with it. Okay, so 2-3 things. And I've had a very similar case myself I've had to deal with. 2 things I'll want to say here is, one, Non-solicitation and non-compete are looked at very differently. The purposes are very different. Non-compete is that you'll not go to a competing organization and another similar company with same business cannot hire you, and so that is non-compete. And non-solicitation will, again, that you cannot solicit, and they are sometimes overlapping, but they also work very differently. And not just India, this is a problem everywhere. I've had this problem even in the US courts, I've had this problem elsewhere, because we have similar general perception, like you said, and I'm calling it perception, not because what you said is untrue. What you said is absolutely true. I had a similar matter and I went to the biggest law firms of this country, where one of our very senior executive vice presidents working for the company for many number of years, not Capgemini, I'm talking of another company, left and joined a competition. And the situation was such that we had to do something, otherwise we would have lost out on literally our bread and butter, because that was a products company. They were building a product for last 35 years, and that would have just gone in a jiffy if we had let that go. So it was also a board decision to take action no matter what, no matter which court, no matter what it cost us, and so on. But anyways, thankfully my experience has been very positive. We went to the High Court and we got an ex parte injunction against that situation and that employee. Of course, there were hiccups, and I'm not saying that it happened overnight. We also filed an FIR because we wanted to take the criminal approach. That never got registered because the police did not understand, the SHO couldn't understand what he needs to register the FIR for. Kya loss hua hai aapka, madam, kya hai, company ka kya leke gaye hain, wo kya le... I mean, it's difficult to explain कि company की intellectual property, company का पूरा source code, company की customer list, it's very difficult to understand when you're talking to somebody at an SHO level. Ultimately उन्होंने हमारी FIR नहीं लिखी, वो भी हमें हाई कोर्ट से डायरेक्शन लेना पड़ा to get the police to register the FIR, but we took two remedies, both in the civil courts, which is the interim injunction that I'm talking of, and we also took the criminal remedy of going and filing an FIR, which also happened. Later, we also got a permanent injunction against that employee from divulging. But again, in this situation, your legal has to be creative to, and I'm saying creative, people think law is a very dry field, but we thoroughly enjoy it because it's very creative. It's how you build your case, how you structure it. Ultimately, we are all performers as litigators, and I, because started with litigation, Gopi ji can tell you, because their firm also does litigation. You have to put your argument in a creative manner that the court understands. The judge that I got in my case was a family matter judge. She had only looked at divorce cases before this, or maintenance and child custody. And I had to explain. When I said source code, she said, what is source code? You are licensing your product to everybody, so your product is available everybody across the globe. तो क्या ले लिया उन्होंने?
One takeaway is that, let's say there is a EVP kind of a guy. Like technology companies typically have this clause in every employment agreement. Now what we found out is that when we talk that an IT guy moving to a competition is a very, he will change the job.
Not just IT, Prasenjit, not just IT. I think this is across industry.
Yeah, across.
Are you recommending that a certain level, this is more applicable than?
No, it's level agnostic. It's, I would say, yeah, you want to say something, go ahead. Yes.
So, okay. No. So, see, non-solicitation is something which is very reasonable. Non-solicitation is enforceable, should be enforceable. You should say rather create your arguments in a very creative manner, just as Lakshika ji also said, and you should say that yes, I have been affected in a detrimental manner due to the solicitation of clients or solicitation of employees that has been done. You have to put up the case well, and it is enforceable.
And
Right.
also it becomes enforceable, you know, you have to, courts are also, I mean, the judges are also human beings. You have to demonstrate your damage. You have to show why it causes damage to you. Don't go to them just because it's an ego matter कि अरे कैसे छोड़ के चला गया. अभी हमें बस उसको एक सबक सिखाना है. It's not that, right? It cannot be hypothetical. There has to be serious. If you can demonstrate that, because injunction is all based on that you've been caused irreparable harm and damage. Means no matter how much money you give me, it's irreparable. That's the premise of an injunction. Sorry.
Now, insofar as a non-compete is concerned, that is enforceable, but to a certain extent. It is not unconditionally enforceable. Just as you rightly mentioned, a junior level associate in a particular company, if he moves from X organization to Y organization, enforcing a non-compete clause in his or her agreement will be a gigantic task. Right? But however, if a CEO of a company moves from Tata to Reliance, wherein that particular person was privy to certain confidential information of Tata, then that is a reasonable restriction that is imposed upon him. And there cannot be a blanket restriction. It cannot be said that you cannot work in the field of marketing. The only thing that I know is marketing. You cannot snatch away his bread and butter. I cannot become a lawyer tomorrow if a person is a marketing person. Right? He has to practice marketing, but there has to be a role-based and some reasonable restrictions will have to be placed. Currently, if you also see, there is also a development that is being made which wasn't quite relevant in the recent past. There has been one development which has been observed by the Delhi High Court, wherein, in a very recent judgment, wherein service bonds have been made enforceable. Service bonds have been made enforceable. Previously, service bonds ka enforceability was something which was a very gray area, wherein you had to show to the court that yes, I have incurred certain amount of expenses on training this particular person, I have incurred certain amount of expenses in motivating this particular person, supervising his or her work. So therefore, I have incurred an expenditure of 1 lakh rupees. So therefore, he has to work in the organization for a period of 1 year. And if he or she does not work in the organization and terminates his association with the company, then as a company, I have the right to recover that 1 lakh rupees from him or her. But now, the court has rather gone forward a step and said that no, even if there is no training that has been provided by this particular company to the employee, it is important. There can be a reasonable clause in the employment agreement by way of a service bond or not, that a reasonable restriction, it cannot be a restriction for 5 years. It can be, yes, the person will have to work for a period of 1 year to protect the health of the organization. Right? That is the words that have been categorically used by the order. It is quite a recent judgment.
So very clearly, what I can say that while we come to the end of the session, very clearly all the participants who attended the program were actually have gained free advice for which we would have actually paid to all these 4 eminent lawyers. So we are very thankful to all of you for sharing some of these insights, and especially the last one. I think that's interesting. I think as GESIA, we would want to come back to you separately and maybe have a session only on that for our GESIA members. Thank you so much. And we'll come to this session. We'll have to bring it to an end because after this we have a equally interesting, if not more, a session on detox. But before we do that, we would like to thank our panelists.